first case study, Schneider Electric and Telvent.
I can set the table for it. That was a $2 billion all-cash acquisition by Schneider Electric, French CAC 40, probably CAC 20, CAC 15,
yeah,
CAC
probably
10 or 11 company, negotiated during May of last year, announced on the 31st, tender offer commences according to the U.S. tender offer rules shortly thereafter, regulatory filings around the world. Tender offer closes in August, so that's a nice timely transaction. Then we had a back-end squeeze out that we had to manage, which we will get to in a moment. We talk about some of the legal complexities of that deal. But Peter, I think maybe you could begin by just telling us, how does a IT company based in Spain make its way onto the radar screen for a French energy company?
Well, I mean, for those who don't know about Schneider, and it could be the majority of the audience, we specialize in a lot of different energy management issues, and one of which is a smart grid and substation automation, ensuring efficient use of energy from the medium voltage side all the way down to the low voltage side. And one of the sophisticated parts about Telvent is their software and their programs that are designed to optimize that substation automation and demand side energy management. They've been on our radar screen and many other companies' radar screens for a long time. Mm-hmm. It's always been one of the nuances we'll get to is they were historically owned by another company and who still owned a 40% stake in them, which added a very interesting element to this deal because you were negotiating not just with one party, but now with two parties.
So Peter, why don't we begin by asking you about the key diligence issues. And diligence, of course, is so critical in any deal. For you and your team, and how did you resolve them?
The first thing is we had to make a decision how we were going to approach this deal. Once we locked up our 40% stake, entered into negotiations. And they're a public company, you got to rely on the public information, and they were very reticent to give us more than what was publicly available, though they did. So it was a very interesting thing. Also, much of the documentation was in Spanish, which is not a native language to the French or the English, so we had that issue. But we also had other issues in due diligence that cropped up because they were formerly a sub. We had a lot of IT issues, a lot of carve-out issues. And we also had a lot of issues that we had to resolve with these joint ventures they had. One in particular was a very sophisticated technological joint venture based in Serbia. And that had to be resolved before we could proceed with the deal because they owned the IP to some crown jewels that were very important to the company. And if you don't lock up these third parties who aren't necessarily owned by the company, so you have these arrangements, and you guys go in there and you say, okay, but I want this and I want this piece and I got to get it, but they don't fully own it. So now you have 3 or 4 negotiations going on at the same time, which intellectually fascinating, deal-wise fascinating, a lot of sleepless nights though, because you don't buy it, then next thing you know, a whole $2 billion deal falls apart.
So you're right, Peter. That joint venture in Serbia, we were aware of it. Some of the documents relating to it have been filed with the target's SEC filings. We had an intimation that there were change of control provisions buried in those documents that would materially affect this transaction. And as we were able to dig during the diligence, we found out that was true. So public deal, very unusual to bring somebody else in under the tent, get permission to go find that third-party consent and enter into a negotiation with them. But that's exactly what the Schneider deal team did, making trips to Serbia, making trips to Madrid, having people come to Paris and working out prior to signing up a merger agreement how that third party would exercise their rights. And it turns out we did obtain the consent and waiver that allowed that deal to go through.
Yeah, at the last minute, but we did.
Right.